This is Attorney Andy Marcantel and Attorney Marc J. Victor. We are the partners of the Attorneys for Freedom law firm here today with a big announcement, and we just figured we would make it on live stream. How you doing today, Mark?
I'm excited, man. I love making these announcements. I love improving our program. I've been telling people for 27 years since we've had our law firm, we're really committed to excellence.
Yeah.
Yeah, and we're committed to improving every facet of what we can do. And really, that's what the announcement's about. I know people, the cat...
Personally, I was just getting upset with us getting dinged on a few different points that some of the other competitors have. It's starting to annoy me. So
Yeah, it's really funny because I have a critique of the Attorneys on Retainer program. It's in the can, ready to be edited and put out there, where I'm critiquing our own program.
like you did with the other
Yeah, with the
programs.
same amount of vigor and saying, hey, look, we don't cover misdemeanors, we don't cover appeals, the bond amount, it's a little bit low, and then I go on to some other things, just to be fair and transparent. But instead of releasing that, I got to do a whole new one now. Because it's true. We made the announcement to our existing members already. So
I think we sent around an email or a bulletin or something like that.
Yeah, I think it went out today. Look, these were real criticisms, and not the biggest criticisms, but we're not interested in having the second best program. And we reserve the right to improve it again if we decide. So it's true. Now the Attorneys on Retainer program is now covering misdemeanors and appeals, and we have increased the bond amount from $25,000 to $50,000. So what that means is you get $50,000 towards a cash bond. If you have a secure bond, then you get $50,000. You still got to come up with the collateral, like all the other programs, but this will handle up to roughly a $500,000 bond. I say that because, sometimes you can negotiate a little bit with these bondsmen out there. I've done that in the past for clients. So there's very little left to critique our program on now. I think we've pretty much covered all the bases.
Okay, I want to break down both of these. In my opinion, the two giant improvements here would be the covering misdemeanors and self-defense cases.
Yep.
And then obviously the bond amount is fantastic and everything like that, but covering appeals is a really important one too.
Yeah, that's a big one.
Let's start with that one actually, because this one's always been really interesting to me. We've complained about it a few times on our program.
Yeah.
And this is that a lot of these insurance-backed companies will proudly tout that they cover appeals.
Yeah.
At the same time, many, if not most of them, are not only is it in their contract, but they're legally required to disclaim all coverage if you're convicted with a crime. So in other words, if you take a plea or if you're convicted of a crime. That begs the question, how do you get to a criminal appeal if you're convicted? Because you need a conviction to get to an appeal. You're disclaimed from liability from these companies if you get convicted. How does one get to the appeal coverage on these programs? I've been scratching my head trying to figure it out.
One of these companies has, in fact, we reference this clip all the time. One of these companies puts out and says, look, if you're convicted or you're found guilty or you plead guilty, all coverage ends.
Coverage stops in the event of a conviction.
It's like that echoing voice.
Yeah,
that just kind of shows
coverage
up every now and then.
stops in the event of a conviction.
And it's true, to his credit, absolutely true.
Yeah, so don't talk to me about your coverage on appeals. Don't talk to me about your civil coverage if you get sued. Because if you plead guilty or you're found guilty, like we know, stats alone are going to say 95% plus. People are going to take a deal in the system.
In every jurisdiction in the United States.
So anyways, we don't have that problem now.
No problem. And then misdemeanors. This one's really great for people in various jurisdictions, right? Because there's different crimes charged at different levels for different jurisdictions. Like a lot of people I saw have been commenting on our videos saying, hey, in California, we actually have a misdemeanor that doesn't involve necessarily a discharge, but could involve a defensive display. And there are other people from many, many other states who say, we have gun-related but misdemeanor designated self-defense statutes and everything like that. We're like, oh, okay, well, we should probably cover those. And so now we are.
I mean, the program's been growing, right? So we're interested in rising to the occasion, in improving the program. And, like I said at the beginning, we might do some other things down the road. We reserve the right to improve the program. I also note we're not changing the cost of the program, and it's retroactive to everybody who's already a member in Attorneys on Retainer.
So there you go. Our gift to you, to our existing members, we now cover all of your self-defense misdemeanors. We are not going to charge you another dime. In addition to that, we'll be covering your appeals if it gets that far. If you're convicted of a crime and you need our law firm to cover your appeal, we're there until the end, because oftentimes those appeals can drag out for a long, long time after a conviction. So we got you covered there. And also, we've increased our bond amount. We talked about that. And we reserve the right, in fact, to increase it further if we so choose. So these are our announcements, and that's our current modifications.
But we still get criticisms on our on hold music. And I think this is a valid criticism.
This
Andy.
is okay. Not only are we committed to the best self-defense program here, we're also committed to the best podcast and live stream, including our hold music. So
Everything.
While I saw, so marketing told me that there were some complaints about our hold music. Mark and I, of course, don't make the decisions on the hold music, but I think we may need to take this into our own hands based on the critiques I'm seeing here. So one listener complained it was so lame. The hold music was so lame. One person opined that it was, quote, lawyer music. I'm not sure if that's an insult or just an observation. Somebody else said it was akin to a doctor's waiting room, which is one of the most boring places one can be. So I think that's something to cause concern. But here was my favorite, Mark. It reminds them of a good-looking blonde in a sequin gown in a Las Vegas nightclub with a guy playing piano behind her. Drinks are $500 a piece. I was like, oh, that really painted a picture.
Yeah,
though a beautiful picture perhaps for a James Bond movie, not exactly the picture we want to paint on our live stream. So help us decide what music to play. We'll be in search of some better music, less excruciating, hopefully, for the next live stream.
We got another area we can improve on. All right, so stand by. We're working on the hold music.
All right, now it's time to get to your questions, my friends. Let's have one of you wonderful marketing people blast one up. There it is. It just went away. Does the AOR program cover individuals who shot or used deadly force to defend a third party? This one's easy. Answer's yes.
Yeah, the answer is yes here. It's actually in the fee agreement. If you take a look at the fee agreement, which we put right out there, you can check this out. Go to attorneysonretainer.us. Go to the top right. Go to the FAQs. If you scroll down there, there's a whole bunch of questions there. One of them deals with the fee agreements, which, by the way, are getting updated now to include the misdemeanors coverage, the appeals, and the increased bond amount. So the answer to that is yes, no problem.
Absolutely. Another question. What do I say to the operator if I show my gun to the threat, they leave, and no shots were fired? I'm assuming that means maybe a 911 dispatch operator, something like that.
This is a really good question, right? Because I think that probably we should put out some information that says something along the lines of, if human life is in danger, call 911. But this is a situation here. You showed your firearm to somebody. They left. There's nothing else going on. There's no reason to call 911. So this one, I would say, call us first,
Absolutely.
right? Human life is not in danger. Call us first. Talk to me or
This
Andy.
is a time you would use the emergency hotline before calling 911.
Yeah, which is, another point about our hotline. Like, we actually have lawyers on the other end, lawyers who would be representing you from our firm. And so let us make the decision about whether you should make. I can already tell you, if there's nothing going on, I'm going to say, you know what? Don't make any calls.
Yeah, we could tell you some horror stories.
Yes.
We have many horror stories in this firm where there would have been nothing at all, no crime at all. In fact, you know the one I'm about
Yes,
to
I
tell
do.
you, the one
Yeah.
that we have in the office that
Right
we were
now.
just working on last week, where if our client had simply decided not to call the police, there would have been no issue whatsoever. Nobody saw it, no witnesses, nothing like that. He used, in my view, absolutely valid self-defense and discharged a weapon, but because he felt like he was the victim in the situation and wanted to do the right thing, he called the police. Well, the police showed up, and lo and behold, they decided, you're the bad guy. We don't have anybody else to arrest, and we have a report of a discharged round from you. So turn around, sir. Please present your hands, and here's the handcuffs, and he's off to jail. So if he had called us first, we would have told him, look, probably not a good idea to call the police. Now, you might call us on that emergency hotline, and you might tell us some facts that might change our mind about
That's
that,
right.
even if human life isn't in danger. Say, for example, you say, And I'm in a crowded bar right now, and there were at least 80 people who saw it, so we're full of witnesses and everything like that. Now our opinion has changed because
Yeah.
somebody's going to call the
In
cops.
fact, we got one not too long ago. You may remember it was on a weekend, and it was a non-emergency call, and it came through, and I got the message, treated it as an emergency anyway. And this AOR member had discharged a firearm, wanted to know what to do, and we made the decision not to do anything.
That's right.
And I just reminded him to keep his mouth shut. Nothing ever
And
became
guess what?
of it.
Nothing became of it, right?
Yeah.
Whereas if he had called the police on himself, essentially, he's admitting to negligently discharging
That's
the
right.
firearm in certain, in certain respects, or within city limits in an
Yeah.
unlawful way. So no crime if he had not picked up the phone. So that's
Yeah.
what
So
we advise.
if human life is in danger, somebody's going to die, you got to get the ambulance there. Fine. We've talked about what to say before, but if not, call us first and let's talk about it.
Awesome. All right. Next question. Your instructions say on the step where the defender calls 911 to say there has been a shooting. What if other weapons are used? Fair question.
Yeah, it's a fair question. And, this highlights the problem of giving general advice that purports to deal with every possible situation, which is why it's very hard to do that. I always hesitate because, every situation is different. We try to give general advice. But look, this is why you have an emergency line, right? Call us. Let's talk about it. I mean, obviously, if you got to make a slight change, right, there's been an incident or something like that. You don't have to say there's been a gun used, but you could say, look, a person down, we need emergency help, send the
Somebody's
ambulance.
injured. Yeah, you can be more vague
Here's
than
the
that.
address, goodbye, and then call us and we'll tell you shut up when
That's,
you get there.
that's fair. All right, next question, guys. All right, we're in a waiting period right here. Oh, okay. They're asking if we don't have it up on the screen, but they're asking about red flag laws, and they want to know if we cover red flag law cases and what is the possibility of covering that type of thing in the future.
Might happen in the future. It's not something we're covering right now. But, I do point
So
out.
we're getting dinged on it right now.
Fine, fair enough. We're getting dinged on it. But, I also point out, and we've changed the language, by the way, in the fee agreement. We used to call them an applicable legal matter and a non-applicable legal matter. People will see with the new fee agreement, we're going to call it a self-defense related matter and a non-self-defense related matter. People forget sometimes that, we're a law firm. We do lots of other things besides self-defense incidents. And so if you're charged with a felony somewhere in the United States, you're an AOR member, you're charged with some kind of a felony, could be completely unrelated to a self-defense incident. You're sued for something, might have nothing to do with self-defense. You might have a personal injury case, something like that. If it's something we do at our law firm, I mean, we are a fully functioning law firm that has been in existence for 27 years. Call us. If you're an AOR member and you got a red flag problem, okay, we don't do it with no additional charge, but we'll probably help you out if you need help.
Yeah, in fact, I just had a gentleman from the Midwest call me with a very, very similar thing, and while he understood that it wasn't a self-defense related matter and didn't think that, we gave him a hefty discount off of it.
Yeah, we
He
do
was very,
35
very happy.
Yeah, we do 35% off the regular hourly rates. But, sometimes we make special deals with people. I'm not saying we always do. We're not obligated to. But look, if you're an AOR member, you're a client of our firm. Think of us as your go-to lawyers. Call us first. If we can help you, we will. If not, sometimes we'll help you find a local lawyer, work something out with them. So make us your first stop.
Absolutely. Yeah, we give recommendations all the time. We love researching because we like building our network of
Yes,
pro-freedom lawyers
right.
across the country. And so sometimes we'll be like, I don't know one in that area of Oklahoma, or I don't know one in, Rhode Island or something like that. And we'll start researching around because we like to build our connections too.
And it's also an opportunity to build a higher level of trust with our clients at our firm. And to build relationships with people. Ultimately, that's what it's about. We're not just some club, we're a membership club. We're a law firm. We have clients. We treat people like family. And so that's what's kept us in business for 27 years. So call us. If you're in doubt, if you're thinking, should I call? All right, just call the front desk. Devin will be happy to talk to you at the front desk.
Devin will take care of you.
No problem.
All right, guys, keep your questions flowing in. Just throw them in the comment section. We got one from Stan Badger here. It says, I know I should not answer questions prior to talking to my lawyer, but what about my spouse or any other friends or witnesses that were there? do they have the right to refuse to answer questions? Great question. I love this question.
It is a great question. So the Fifth Amendment, really, the right to remain silent operates on somebody who's in jeopardy, who has a risk of being prosecuted. Nobody can make you talk, and you don't have to talk if you have a court order. It gets a little tricky, right? Because I can't say don't talk to the cops if you're not a client, right?
Right.
Because now I'm potentially witness tampering,
right?
and I don't want to tamper with witnesses because nobody owns the witnesses. But you get to make that decision. And, I like to tell people, if you prefer to consult with us before you make a statement, that's our preference as well. So you don't have to make a statement right there. Plus, who knows if the police officer might think you're an accomplice, you're involved in some way. So I always say be cautious at the beginning. Don't make a statement right at the beginning. If you call us and you talk to us and there's a favorable statement, right? There's a really great self-defense. We can make that statement to the police. I've done this many times. Or have the witness make a very detailed statement. If we've got time, sometimes I talk to the witness and say, look, you could say this, that, and the next thing. Make sure that gets in the police report. That'll really help out.
I want to be really clear what the answer is actually to that question, though, as much as we appreciate that pontification there, Mark. The answer is no. Nobody at the scene is required to talk to the police. And if people, while we, can't force witnesses to talk or not to talk, we can inform them of their right not to talk to the police. And this is an important point because the Fifth Amendment protects against compelled speech. So if you're put on the stand, even if you don't want to talk, the idea is that you can be forced to talk and give your testimony. Well, the Fifth Amendment limits that for people who are exposed to criminal liability. So a witness who's not on trial and not in jeopardy of possibly getting implicated in any sort of criminal act doesn't have this type of a right to invoke the Fifth. It's just not something that everybody can invoke. You have to actually be in jeopardy of being convicted or charged with a crime. But that doesn't mean you have to talk to them at the scene. Every single person at the scene can say, I'd like to speak to my lawyer, and that's the end of questioning. That's an important point, too. People screw this up a lot, and as it turned out, I was shocked. When I went to law school years ago, I was shocked to find out just how much case law and jurisprudence there is surrounding the exact words you have to say to invoke your Fifth and Sixth Amendment rights.
Yeah.
There's some magical words you got to use before the Constitution turns on.
That's a good point. We should just spend a second on that and talk about that. If you say, I want my lawyer to be present, then what that means to the police officers, they can't ask any more questions. They don't get to keep coming up with more and more creative questions. But if you change that statement to, I think I might need a lawyer, or do you think
Do I need a lawyer? We've had that before.
That's like
I
saying
think
nothing.
I need a lawyer, yeah.
Yeah, that's like saying nothing. You're being equivocal here.
And in fact, they can even tell you, arguably, they can lie to you. They can say, oh, no, lawyers complicate things. You don't need a lawyer. We've had plenty of cases where the officers who are allowed to lie to suspects in order to try to get a conviction will say things like, look, if you just tell me the truth of what happened, we don't need to get the lawyers involved. I'll make this all go away. I can close the file on you, things like that, and then entice our clients to make incriminating statements. So don't fall for it. Don't do the government's job for them. Just shut up.
There's a really fun case on this if people are interested. Rhode Island versus Innis. I don't know if you remember that one.
Yeah, I do. I remember
Yeah,
that
where the police officer is making a statement that the court said was reasonably calculated to elicit an incriminating response. So in a situation where the person has said, I want my lawyer present or something like that, they could be in the backs. The officers could be talking amongst themselves. There's another case, the Christian burial speech case.
Right.
Well, wouldn't it be nice if this we knew where the body was and this deceased person could get a good burial?
Which was said, yeah, just to be clear, this was said by the officers to one another in the front and passenger seats intentionally while the suspect who had just invoked their rights is now sitting there listening to this guilt trip being laid on them, cracks to the guilt and confesses. The Supreme Court said, you can't do that either.
To your point, there's a lot of case law on this stuff, and so it's very hard. This is the kind of point where you might spend quite a bit of time in law school going over. So it's very hard to just give a quick question. I would say, look, if you have time before you interact with the police, call us.
That's right.
Yeah,
I think that's a good blanket piece of advice.
That's a good blanket piece.
That's as close as we'll get to blanket advice today, folks.
Yeah.
All right, let's get another question up on. From Eugene Dove, we got, can you please answer, can I use, for example, paintball gun to defend my car against unarmed suspect in Florida? Okay, so we're dealing with a non-lethal force analysis here. And the answer is, well, it depends, because we're also, to kind of make that an interesting question, we're not defending against a person, we're defending against a piece of property. So non-lethal force to defend property. What do you say, Mark?
Well, first of all, I don't want to give an answer that's specific to Florida, right? Unless we specifically pulled the Florida statutes. But as a general matter, you don't get to use deadly physical force to protect property. You can use ordinary physical force to protect property. And so what's the difference? Well, is it the kind of force that's likely to result in a serious physical injury or death? So you might say, okay, I know what death is. What's a serious physical injury? And there are cases on this, and different states look at it differently. But as a general matter, if you're talking about broken bones, if you're talking about something someone's probably going to have to go to the hospital for, you're talking about a serious physical injury. So ordinary physical injury or things, think like fist fight.
Mm-hmm.
Although even that, if you're dealing with somebody who is frail, as we like to call an eggshell plaintiff in the tort world, even a punch in the face could be a serious physical injury. So it's very.
Or if you're dealing with multiple people, maybe ganging up or jumping one person, that could be potentially lethal
Yeah,
force.
I think the best way to answer this question is just to remind the person that if you want to respond with self-defense, you should remember to use the least amount of force that is reasonably necessary to repel that imminent threat. And so, if the paintball gun is more force than you could use you could stop the threat with something less than the paintball gun, you should.
Yeah, I agree with that. So, like, let's say somebody is breaking into your car and then you see them break into the car and you shoot the paintball gun. I would be shocked if you hit that person and it stopped them from breaking into your car. I would be shocked if a prosecutor brought that
Yeah.
case, in my experience.
Me too.
But I've been shocked before.
Yep, me too.
And so it really depends. And then there's also the possibility I've seen people intend to use less than lethal force, and then it becomes an aggravated assault because an unexpected injury is caused. Let's say the paintball, for example, accidentally flies in the person's eye, or perhaps intentionally you shoot the person in the eye and they lose an eyeball because of it. Now that fits the definition of what counts as aggravated assault in many jurisdictions because it involved a serious physical injury. Prosecutor can say disproportionate for somebody trying to get into a piece of property. Therefore, here's your charges.
Yeah, I tell people at the gun show where I've been speaking for over 2 decades now that if you can avoid the problem, avoid the problem. Even if you think you're in the right? Because, being prosecuted can be a big deal. Even if you're an AOR client and we're picking up the tab, right? You don't have to pay. Still going to be an awful lot of stress and aggravation. If you can avoid the situation, best to avoid the situation.
Excellent point. We just did this video today on Mr. Vince Ricci out of Lubbock, Texas, and you
Yes.
guys should keep your eyes out for that video. This case perfectly exemplifies your points. Is why
Yep.
we tell people all the time, when you pull your firearm, even if you don't discharge it, but especially if you discharge it, even if you're legally justified, expect a lot of aggravation.
Yep.
And this guy, the grand jury said no crime here whatsoever a year and a half ago, almost 2 years ago, and he's still dealing with the fallout of the civil suit.
Yep.
So
And he could have been prosecuted. I mean, I could see that one going the other direction as well. But
in a different jurisdiction,
yeah,
especially.
absolutely.
Yeah.
Absolutely.
Okay, let's put another question up there on the board. I second the comment about getting some AOR swag. I need an AOR shirt to wear at the SHOT Show. Awesome.
That's a good suggestion.
Do we have AOR swag? I think we were in the process of getting marketing some together. I don't know.
All right, well, let's leave that for another big announcement for our next YouTube live.
Now with swag. No. Well taken, guys. We want you guys.
I just got some. Eric had an announcement.
Oh, okay. Eric? Eric's
came from heavy duty country.
okay. Oh, that's HDC. What up, man? Yes, we're definitely going to get some swag, and you'll be the first to receive it. You can let us know what you think of it, and then if you like it, maybe huck it on your program. We sure do like your program, man.
Yeah.
It's awesome.
He's the bomb. No
Awesome.
doubt about it.
All right, moving on. Moises Cruz. How do we treat a self-defense use of a firearm against animals? Ooh, I love this question. The act of protecting ourselves and our pets against wild animals, or other pets. Oh man, we've had this case so many
Yes,
times,
many
and I love
times,
it.
many
Love it,
times.
love it.
So yeah, there are obviously big difference between protecting ourselves and protecting our pets, right? So we got to start there. We've had several cases where people have taken their firearm and shot a dog. And sometimes, usually, that dog's attacking their dog, right? That's what happens. Somebody's walking their dog, and the mean dog comes over there and starts attacking their dog. They pull out the gun and shoot the aggressor dog.
Can we pause real quick? Let me tell you why I love it. Let me tell our viewers, because I've talked to your head out about this. Let me tell our viewers why I love this topic so much. Because animals, it's one of those areas of the law where we ascribe to them pseudo-human rights. Pseudo-human rights.
That's right.
In certain areas, like, for example, in many different contexts, like the one that you just described, we treat them as property.
Totally
It's
property.
the exact same as if somebody was trying to tear up your handbag or
That's right.
deflate your basketball or break your candle. We treat the dog as that exact same status legally for the scenario you described. But at the same time, you can't let it starve. You can't deprive it of food. You can't. We have crimes for all these
We've had
things.
many-
Cruelty to animals.
Yeah, we've had many of those cases as well.
Many of those. We're very concerned as a society about their well-being and safety and health and everything. So it's really interesting when you analyze animals in a context outside of animal welfare in the criminal defense
Yeah, so
context.
the bottom line, I think the guy who shoots the dog, if he keeps his mouth shut, as we recommend, he comes in here and talks to us, he's probably going to be fine. But if he opens his mouth and he says, the reason I shot the dog was because he was attacking my dog, he's probably going to get charged.
You just shot somebody else's,
You just use deadly
Property.
physical force
Yeah.
to protect property.
That's it.
If, on the other hand, he says, that dog was attacking my dog and I thought he was going to attack me, and that's
Or was going after my child or a
Yeah.
third party or
Yep.
something like that.
That's a completely different justification. This is one of the reasons you keep your mouth shut, right? And you come in and you talk to us because we've had this situation before several times, right? We've had both the person who shot the dog in different scenarios and the person who neglected the animal as well. We've had many of those cases. So it really, I tell people at the gun show, right? Mere words alone. If I say something really offensive to you, you don't get to use self-defense. But if I say exactly the same thing, and I got my fists like this, and I'm approaching, that's a completely different situation. So the somebody, when asked, why did you punch the guy? If the answer is because he said these offensive things to me, that's your aunt, you're going to get charged. If the answer is because he said those terrible things to me while he was approaching me with his fists like that, which he probably was, right? You may have just forgotten to mention that. That could be a complete defense. So, how you characterize this at the very first time you open your mouth, which, remember, oftentimes is at the scene. You got the adrenaline flowing and you're excited about it. It's the worst possible time to be making a statement. So and you have a right, you have nobody's doing you a favor to respect your right to remain silent. This is a hard-fought, bloodshed, people died kind of a right to remain silent. And so there's a reason we have a Fifth Amendment. Keep your mouth shut and talk to your lawyer first and let us figure out whether it makes sense to make a statement and what that
Somehow, in
statement
all
should
of these questions, we find a way to come back around to rule number one, which is just shut up when the cops
be. We
come around.
say that because how many cases, Andy, from where we sit, could we have gotten a better result or gotten the person completely off if they just kept their big mouth shut?
It's depressing. And
It is.
usually the worst evidence in the entire case comes directly from the defendant's mouth. So.
Very often.
And I'll say one more thing about this scenario of shooting animals. I want to throw a disclaimer before I say this because I do not want to encourage people to just start plugging away at dogs, unattended dogs who are trespassing or running around your property. That being said, if it is an unattended aggressive dog that's trespassing on your property and you discharge a firearm under the theory that it was posing an imminent threat to you or a loved one or something like that, I have seen particular deference in certain jurisdictions where they're going to work with you a little bit more, perhaps be a little bit more lenient on the discharge of the firearm.
And also keep in mind where this is occurring, right? There's a difference between this happening out in the countryside somewhere and then this happening in the middle of a crowded neighborhood. The prosecutor will look at the discharge of a firearm very differently there, not to mention the fact that that round could go anywhere, and you're going to be responsible for where it goes.
Yeah, that reminds me of a case that I had years ago where my client, his dog, he had a small dog on a leash, and it was being attacked by a bigger dog on a leash. And it was in the middle of a crowded, of all places, a marijuana convention. And everybody was walking around. My client actually discharged into the dog towards the floor, ricocheted off of the concrete floor, and hit the victim in the foot. So that can happen,
I
too.
remember that case.
Yeah. All right, let's see the next one up there. Tim Shannon. Biggest competitors slam on AOR is that there are no actual attorneys in your area. And any answer to this? Excellent question. Love this one. We're in your area when you hire us for the case. Once we take the case, we will come to you in the United States. Now, that's after we get a Pro Hoc Vice counsel. Mark, you want to talk about Pro Hoc Vice process?
Yeah, in fact, we're going to be releasing a video. We've already recorded it. It's just in editing right now because so many people have asked, hey, what happens? I'm in Kentucky or whatever, and I get involved in a shooting. How's it going to work? And people still, they really don't quite understand. They say, who's my local attorney here? Those kinds of things. And so we've organized what we call a strike force at our law firm. Everybody knows their job. This isn't our first rodeo. We've been doing what we call the late night freedom fight for many,
Yeah,
many
we
years.
definitely need a cool theme song for the strike force, Mark. If
Yeah,
we're improving our hold music, we need a cool strike force theme.
For sure. So, but anyways, what happens is, and I think maybe next week or the week after, AOR members are going to get a notification that there's a form for them to fill out in their online portal. And in that online portal, there's going to be a whole bunch of questions, the kinds of things that we need to know for that very first hearing. We know this because we're lawyers. We've done these hearings many, many times. And among those questions will be a couple of other questions. Number one, who is your choice of a preferred local attorney? And then number two, who is your choice of a preferred local bondsman? That's going to be our first choice, right? Say the emergency happens at 2 o'clock in the morning and we're on the phone. And sometimes, police show up. The second you're on the phone with the person, say, hey, you're under arrest, put your hands behind your back. The phone goes quiet. The client's gone.
Right.
Well, we can then get into the portal, get all the information that we need. If there is a local attorney, that'll be our first call. They may or may not answer. And then we'll continue to work on it till we can find somebody who we like. And what does that mean? Our team already knows what we're looking for. We're looking for somebody who's an experienced criminal defense lawyer, someone who's not afraid to try cases and work hard. Also, pro-Second Amendment, pro-freedom, somebody who can contribute to the team. And then we'll get that information to the local attorney immediately.
Yeah, just real quick, it's like we were talking about earlier about why we like to take cases in different jurisdictions, even if they don't qualify under self-defense, because it gives us a chance to build our network a
That's
bit.
right.
Doing this program, we've made great alliances with lots of attorneys all over the country who we can put our stamp of approval on, who could meaningfully contribute something to our local Pro Hoc Vice.
You got an amazing result on a federal case in California this year. I wish we could talk about it. It was an incredible result, but we can't talk about it. But yeah, we do out-of-state cases all the time, not a big deal. So once we get past that emergency release hearing, which likely is going to happen 24, 48 hours after that arrest, the very next thing is we're going to be sending out a motion. We've already drafted. We've already got all of the requirements for each of the 50 states ready to go. And they'll be filing a motion to admit us, what we call Pro Hoc Vice. It means you get admitted for one case in that state to do that case. At that point, we're lead counsel. We fly out there, we do the hearings. If there's a trial, we'll be lead counsel for the trial. They probably are going to get two lawyers. I mean, you and I probably will go and do some of these because
rather than just fight over who gets to do it, we'll probably just say, all right, co-counsel, let's do it.
We're going in to crush, right?
That's right.
We're going in because we want to crush the case. We want to do our very best work on it and, do what we've been doing. There's a reason we got all these 5-star reviews.
That's an excellent point, okay? That's the problem with the other programs is that you don't know who your lawyer is going to be for the vast majority of these other programs. You're hoping that they get you somebody good. But their program, if they get a shitty lawyer here or a good lawyer here or something like that who does an insufficient job for whatever reason, their program's not going to rise or fall on that. They could just simply pick a different lawyer next time.
Right.
Our program rises and falls on the quality of the legal representation the Attorneys for Freedom give, period. If people aren't excited about our law firm and what we stand for and the job that we do for people, they're not going to be excited about getting the AOR program.
That's
because
right.
we are your lawyers.
We are not confused about the fact that if you don't want the Attorneys for Freedom law firm, the Attorneys on Retainer program falls apart. We're not confused about it. We're all over it. So we're looking for opportunities to go out there and impress people. As that's how we've been in business for 27 years. We've been doing our best to impress people. We really are committed to excellence at our firm. It's something we talk about at every firm meeting. It's tough to be at this firm. We hire a lot of people. We let a lot of people go. I'm not going to accept the second best. I tell people when we hire them, and you know this, Andy, I say, look, you might be called into my office and told you're doing a good job, but then we let you go because I'm not going to settle for good. Not interested in good people because that leads to a good firm, and I want the best firm, which means we got to have the best people.
Absolutely. All right, let's get another question up. All right. Did you ever make a response video about James Reeves? Yes. Yes, we did. It's in the can right now. We're finishing editing on that. Didn't he pull that video, though?
He did. The video's unlisted. I think maybe someone let him know we were going to do a video on this, but too late.
We screen captured it. Ha ha.
The video's coming out. It's going to be a fun video.
Hold up real quick before we start bashing on James Reeves. Okay.
We're not going to bash on James.
We're not bashing. Okay, well, hold on. I don't want people to take this the wrong way. First of all, I think he's probably a good lawyer.
And we said, yeah.
Based on the videos that I watched and his analysis, I agreed with the vast majority of things that he said, right? This critique is based on an opinion about self-defense coverage and things like that. But as far as him as a legal mind, he seems like he's probably a good lawyer.
And I understand why he wants to lump the attorneys on retainer program in with the insurance-based programs or the prepaid legal programs. But as people will see in that video, I pulled out the definition of prepaid legal that the American Bar Association brought, and we are not prepaid legal, we're not insurance, we're a law firm. And so it's very easy for us to distinguish from these other programs. But people have to wait for the video. I think it's going to be coming out within a week or so.
Yeah, I would also, and I don't know if we said this, we usually say stuff like this on our videos. We may have said it just as a routine, but just in case we didn't say this, I would encourage Mr. Reeves to reach out to us.
Yes.
If he thinks we got something wrong, I would love to have a
Absolutely.
podcast with the guy. Like I said, he seems like a good lawyer. Maybe after we get off the subject of how wrong he is in his analysis about our program, we can actually get into some gun law, which would be a really interesting conversation. So
Totally
I'd
open.
love to talk to the guy.
Totally open-minded.
Hit us up, man.
Yeah.
All right, next. MWNEPS. Not sure how to pronounce that. I keep seeing the argument that people feel that being represented by a local attorney would be more beneficial because they understand the prosecutors and judges better. What are AOR's thoughts? Great question.
Yeah, I think that's an excellent point. And that's part of the reason why we want to have a local attorney, because there are some things, right? Part of the things that we've had many, many different local attorneys in the times every time we go out of state on a case, we have a local attorney. And some have been better than others, but the ones that have been the best have been the ones that have filled in those little areas. I can say, okay, this kind of judge is like this. Here's a little nuance about our local rules you may not have known, or something like that. That's a very good critique. And I think it's one that we fix if we get a good local lawyer, which is what we endeavor to do.
I remember in a recent one that we had, and also one we can't talk about, but in Las Vegas, we had local counsel over there. I remember before we even set foot in the courtroom, before we did anything at all, we had a long meeting. We've researched and we found an excellent local counsel. And I remember we had a long meeting. What's this judge like? What's this prosecutor like?
That's
What are
right.
the local rules here? What can you tell us about that? It's really, really helpful. And some local counsel will even get you on a call with the judge's staff and with the prosecutor
right.
and make introductions and everything. It's great.
You know, I'll also say this though, I wouldn't put too much stock in it, because even here, when I hear lawyers talk about the judges, there's a lot of different opinions, right? It's very hard to pigeonhole and say this is this kind of a judge. Well, maybe that judge was this way in one particular case, but could be a completely different way in a different kind of case. So you don't want to get overly confident about pigeonholing a judge or a prosecutor, right? Because there are many times as well where people have different varied opinions on prosecutors. So I think we take the input and I think we use it for what it's worth, but I don't want to put too much stock in it either.
Yeah, there's also problems with, particularly in more rural jurisdictions, but I certainly see it in urban jurisdictions too, where the attorneys tend to get in a good old boy attitude with one another and kind of wheel and deal. and everything like that. Oftentimes, Mark, as you know, we're contacted by people outside of our more urban jurisdiction where a law firm is located in, because they say, look, everybody over here is corrupt. The defense attorneys are in bed with the prosecutors. They all, shoot golf with each other. I feel like they're totally making a deal and making, well, you helped me out last time on this case, so I'll help you out this time on this case. And my individual case isn't being given the attention it deserves. And I'd like to grab somebody completely outside of the jurisdiction. So
That's
there's
right.
certainly a lot
Yeah.
of, and we got no allegiance to these guys,
Right.
by the way.
Yeah.
So I got no problem coming in, scorched earth policy, throwing a bunch of hand grenades around. If it gets the best result for my client, that's damn sure what I'm
Yeah,
going to do.
I think sometimes in the smaller jurisdictions where everybody's all chummy with each other, there's a little bit of resistance to sort of ruffle some feathers,
Right.
bring some more creative out-of-the-box motions. And as you point out, we've been very successful in those rural jurisdictions because we are definitely not afraid to ruffle the feathers.
Absolutely. All right, let's get another one. 7 Wildcat 5 says coverage on tribal nations. How does that work? Thanks, Mike.
Yeah, I think it works exactly the same way as it works in another state.
Sure.
We'll get somebody there. The tribes have their own rules, and we've been on the Indian reservations before. It's pretty common here in Arizona. We would endeavor to get a local attorney who knows what they're doing, who understands the nuances of the local rules, the judges, all the things we talked about, and get admitted there and move forward like any other case.
Yeah, a couple provisos on that. A lot of times when felonies come off the res, they're charged in federal court.
Yep.
Federal court maintains jurisdiction. The federal
good
criminal
point.
court maintains jurisdiction over most tribal felonies or felonies committed on tribal
That's right.
land. Now, that being said, they do have tribal level charges, which I've handled a few of those before. There's a few extra hoops you got to jump through. You got to make sure you got to get a local counsel, even if you're in the same state. You got to get somebody to sponsor you, and you got to get a special certification to work on that if you're not certified already in that tribe. But bottom line, it's all extra procedure that we're happy to jump through.
And it's another point that you raised I think is important. Most of these cases, they go to federal court.
That's right.
And a very small percentage of criminal defense lawyers actually go to federal court. We're in that small percentage, right? We do a lot of federal
I
work.
love federal court.
Yeah, me
Mark.
too.
Mark, federal court is my favorite.
I've
I
been-
love state court. I love big, nasty felony cases in state court, but I love federal
We've
court.
been doing federal cases at our law firm since we've had a law firm here. Andy and I have tried cases in federal court. We've had all kinds. I was just at the Ninth Circuit about a month ago
Yeah,
now.
yeah.
And so, we love doing federal cases. So we are not a law firm that has a very narrow range of experience. We do lots of different things at our firm. So just thought I'd throw that in there.
Yeah, we have years and years of handling everything from the dinkiest little misdemeanor to the most serious. I'm in a first-degree murder case this week.
With the
so-
death penalty alleged. And
Yeah.
I've done several of those at trial.
Absolutely. All right, guys, let's see another one. Paycheck income. Question. If I have the family plan for myself and wife, are my children covered as well? All are under 18. Thank you. Good
Yeah,
question.
The answer to that is no. They have to be signed up in the family plan.
Individually signed up. That's
Yep.
right. And so we give discounts for that. In fact, I think the more people that you have sign up, we can give you some discounts and we'll work it out with you. But you need to get each person who's going to be covered by the plan registered separately.
Yeah, and one thing on that, you don't have to live in the same house. Some people ask that question. And you can add people later. I got that question today from a person who signed up in the family plan. Said, hey, I got 3 more people I want to sign up maybe next week. Can
I
still
found a
do that?"
few family members kicking around. I was hoping they could sign up. Sure.
Yeah, not a problem for us.
Yeah, awesome. And they'll all get the discount.
Yep.
Gunfighter concealment. What happens if you are a AOR member and now need your services, but you are not granted Pro Hoc Vice? Okay, great.
Yeah, this
Mark,
is
have you ever not been granted Pro Hoc Vice in your career?
not only has this never happened, I've never even heard of it happening, but in our fee agreement, by the way, you can see this if you go to the FAQs and pull the fee agreement online. There's a case, I want to say it's the Gonzalez case.
Brand new. Yep.
Yeah, it's a case that we cite in that very section of our fee agreement. So the short answer is if we ever were denied a Pro Hoc Vice, we would fork out the money to have the local attorney handle the case. So we're not going to leave you hanging. But beyond that, there actually is a case that the United States Supreme Court dealt with on this very issue. There was a lawyer. He was granted Pro Hoc Vice, but it was alleged by the judge that this lawyer violated the local rules, and it was really kind of a dinky thing.
Stupid, yeah.
The local rule, which
Like
is
he passed a note or
yeah,
something
the local
like
rule, which is a common rule, which is only one lawyer gets to do the questioning. Okay, so the other lawyer, who was the out-of-state lawyer, admitted pro hoc vice, passed a note to the local lawyer who was doing the questioning, and the judge says, that violates the rule. You can no longer serve as pro hoc vice counsel. Well, the case went to trial, and the pro hoc vice attorney was kicked off the case, and the person was convicted, and it's made it all the way up to the United States Supreme Court, and the Supreme Court was very stern about this. You got a Sixth Amendment right to select the counsel of your choice. They said, we're not even going to look for prejudice here.
Yeah, in other words, in non-lawyer terms, we're not even going to look whether this hurt the
That's
defendant or even had any influence whatsoever on the verdict or conviction.
The answer is you were hurt because you had a right to choose your lawyer and you were inappropriately denied that Sixth Amendment right to choose your counsel. Now, they didn't say you get anybody, right? You still got to be a licensed member of the bar in good standing and all that. There's a few hoops you got to jump through. Of course, you got to pay the fee. The government doesn't do anything unless you pay a fee. So if you jump through those hoops, and by the way, we have the hoops for all 50 states, no problem, and we're prepared to jump through the hoops. They're generally pretty easy. You show you're in good standing, you pay the fee. Sometimes you need a statement both from the bar and the Supreme Court. You got to say no disciplinary action, those kinds of things, and then you're admitted. So really not going to be a problem. But even if it was a problem, then we don't leave you hanging. At the beginning, we had it in our fee agreement that, sorry, if we're not admitted pro hoc vice, I don't even, maybe we didn't even deal with it. And people asked this question, so we changed it in the fee agreement. But I've never even heard of somebody not being admitted pro hoc vice who is otherwise in good standing with their bar association.
Yeah, so bottom line is, in the extremely unlikely event we are denied pro hoc vice admission in your state, we have a provision that covers us in the fee agreement. We're still going to pay. At that point, we basically just become like the other insurance-backed programs, except we don't have to jump through all those hoops and get around all the exclusions and everything like that. We'll just pay for your...
And you kind of have, it's kind of like in football when they throw the flag and then you throw it deep. Because what happens, if you did get convicted in that case, you got a great appellate issue. You cite that Gonzalez case and say, you know what, I wanted a pro hoc vice lawyer. My lawyer was denied, and I want a reversal. I want a new trial. Read that case if you're interested in that. You can find it in the fee agreement that is posted online.
Yeah, that's really interesting because that kind of turned a light bulb on, Mark. If we ever were denied pro hoc vice, we'd be all over this with the Gonzalez case. We would probably be calling up our local counsel and say, let us help you file something to appeal this decision based on the Gonzalez case and maybe even move the bus a little bit forward on the freedom world.
It's as close as you get to a slam dunk automatic reversal. If you lost your trial, you get a new trial. So read the case for yourself. Don't take my word for it. But you will see there's a good reason why other states can't just say, sorry, we're not going to let this lawyer from another state who's otherwise in good standing come into our state and represent this person. There's a reason you got a Sixth Amendment right to the counsel of your choice, and they can't unreasonably withhold that.
Cool. All right. Next one. 1060 West Addison Street. Do you have coverage if you're a CCW holder charged with not properly securing your weapons while traveling in a state that doesn't recognize your CCW?
Well, remember, we have two different portions, and everybody focuses on the self-defense stuff because that's what all the other companies do, right? And that's the part they see us competing with. But we also have the non-self-defense stuff. So, of course, this isn't a self-defense issue. So this is not... I guess I would use the word covered. This doesn't kind of come under the self-defense.
Yeah, remember what's covered. It has to be, first of all, it has to be, now, it used to be, it has to be a felony. Now it has to be any crime, so any criminal charge or reasonably foreseeable that you're going to be charged.
That's right. You don't actually have to be charged.
Right.
And some people ask that question. If you think you might be charged, that's good enough for us.
Good enough. Then it has to occur after you actually signed up, right? That's an important point. You have
kind
to
of a
sign up
no-brainer.
Yeah, it's kind of like, and then after that, it has to be...
You have to at least in good faith say, hey, I tried to act in self-defense.
What I like to say is that it's the type of thing where we're going to be able to argue in good faith for a self-defense jury instruction, right?
right.
Like we have to, it can't be frivolous. You can't have gone into a bank and, give me all your money and then claim
Yeah, I
self-defense.
like to say on this point, if the judge is agreeable to give a self-defense jury instruction, in other words, it could be argued to the jury, this is a self-defense case, then that's good enough for us. I mean, so if it's a bank robbery, right, and you're charged with bank robbery and you stuck a gun in the teller's face and now you're charged with armed bank robbery and you say, I'm going to argue self-defense, the judge is going to say, sorry, this is not a self-defense case.
So back to the question, because that doesn't fit, like even if this occurred after you signed up, it's not a self-defense issue, so it doesn't get the free coverage. That's what we're selling. That's our product. But we will help you. If you want to get a deep discount on that, we're going to take off, I think it's 35% for any
Yep,
non-applicable.
it's 35%. So you're not going to get it for free,
matter, yep.
but you get what I like to call the friends and family discount. It's it's the point at which we're probably not making a lot of money on it. We're covering our overhead. It's a 35% discount off our regular rates, but we're not going to do it for free. But this applies to really the whole universe of things that pretty much we do at our firm. You could be charged with all kinds of things. Think about all the things you could be sued for. You could be sued for defamation. You could be sued for a breach of contract. And so I think a lot of people who join...
a lot of people and most people get sued. Most lawsuits are from car accidents and
That's
people
right.
cause injury and
Yeah,
things like
say
that.
you don't have coverage. Your insurance expired or something. Now you're being sued. So a lot of people, I think, focus so much on the self-defense portion of this that they forget that there's this non-self-defense portion, because we're not just a membership club that's out hiring lawyers. We're a law firm already we have a busy civil department. We do lots of other criminal cases besides self-defense. So we give you access as a client of a firm in the Attorneys on Retainer program. You have access to the friends and family discount pretty much for everything we do at our firm.
Let me make one more important point about that question, which is that while we're happy to cover it, even if you're actually guilty of the regulatory
That's right.
violation.
Yes,
So
that's
let's
a good
say that you
point.
are factually
That's right.
guilty of a crime in that hypothetical that you hypothesized there. We're covering you, no problem whatsoever, because we're a criminal defense law firm. We don't have to disclaim liability.
Yeah, back to the bank robbery example, right? So the bank robbery example, we say, okay, sorry, this is not a self-defense. We can't argue. But you're charged with an armed bank robbery. We do these all the time. We've done a bunch of them. You get a 35% discount if you want us to do the case. No problem.
Don't go rob a bank, everybody. Be
don't.
responsible, gun owners.
But
All
if
right.
you do, you have a discount.
All right, next up. Werewolf 6. In the event that a client has so-called coverage with AOR and other similar providers, would that be a problem for AOR? Would AOR work with other attorneys? Absolutely.
Yeah, this comes up from time to time where people ask the question, and I think it's going to come up less now, right? Because some people said, well, hey, you guys don't offer misdemeanor coverage, and I want that, so I'm going to stick with another program. Will you guys work with someone else? Yeah, no problem. My attitude is...
But whenever we got one of these questions on our YouTube and they say, hey, you guys don't do this, what if I keep, U.S. Law Shield or USCCA or something like that? Can I also keep the answer is yes, but it always made me cringe a little bit. I was like, they shouldn't have to.
Yeah.
There should be one program that offers
You're probably
all.
wasting your money, but if there, maybe there's training or something else or some reason you want to keep the other program, that's fine.
So the way to get us to cover the red flag laws is just keep commenting on our YouTube, and it's eventually going to make me cringe enough. We'll have to change it, I guess. But go ahead, Mike.
Yeah, so happy to look. Every time you do a death penalty trial, you have to have 2 lawyers on that. That's a requirement, and so you're always working with another lawyer. And I've never had a problem working with another lawyer, as long as the lawyer is competent and is, I like to say a real criminal defense lawyer, which I think is probably most of them, right? If they're really dedicated to getting a good result for the client, their attitude is, before my client is going to have to go spend 1 minute in a cage, they damn well better be able to prove every element of the crime beyond a reasonable doubt, even if the guy's guilty. If that's their attitude, they'll probably fit right in fine with us.
If we were in a church right now, I'd give you a big amen.
Happy to work with
Well stated. Next up, Mike T. Can you address the use of less than lethal force on an aggressive person? If someone is irrational and getting in my space, would you advise pepper spray as an attitude adjuster first? AZ legalities. Love this question. Less than lethal force. We were just talking about this today on an unrelated video that we were doing. That would be something I would call on the defense attorney wish list before
Yes.
you discharge your firearm. We want to see a gradual escalation of force. And like we were talking about earlier with the paintball scenario, hypothetical, anytime that you have a chance to use less than lethal force and you can use something else that's necessary and it's actually effective, that's on our wish list because we want to argue to that future prosecutor, that's future hypothetical prosecutor if you're charged with a crime. We want to argue to that person, look at all the steps that my client took to avoid using the firearm. Look, he tried this, he tried this, he tried this. He made a verbal warning. He then displayed the gun. He then used pepper spray, which is non-lethal. And then at that point, and only at that point, he had to discharge the firearm. We're going to look better on the reasonableness
Absolutely, yeah.
analysis.
If you can avoid using the shotgun for the attitude adjustment, that's
Yeah.
definitely preferred. I mean, it'll get the attitude adjustment done, no question. But if you
Make
could
sure
get
it's facing the right way or your
yeah,
attitude
that's true.
will be
Yeah,
good.
that's right.
We've had that case, in case you're wondering.
If you can use, look, there's a reason why the police officers have a whole different continuum, spectrum of force that they get to use. Because it's appropriate to do that. So, yeah, use the least amount of force that is reasonably necessary to repel the imminent threat.
All right, they're telling me we got time for one more question here before we wrap up. Tactical Warrior asks, do you cover people that carry in a constitutional carry state that doesn't have a CCW license? Answer, hell yeah.
Yes, no problem. We'll cover you if you're prohibited possessor. We'll cover you if you're a place where the firearms are prohibited. We'll cover you if it's domestic violence.
If it's an illegal weapon, I mean, if there's regulatory problems with it. And we've complained about this a lot, that a lot of these other companies disclaim these people for what are unrelated issues, whether or not you had the gun in the correct place or it was even a correct gun or it was the right person to hold the gun is irrelevant to the question of whether you were justified in using self-defense in a given scenario.
Yeah, you know, I've critiqued many of these other programs, and to my knowledge, we are the only program that has in our agreement, here are the things that are not excluded. So I encourage you to take a look at our fee agreement. In fact, I think we're going to have a new one up there in a few days that reflects these changes. But there's a section in there pretty close to the beginning that says, these things are not excluded, and then there's a laundry list of the things that you typically see in the insurance-based programs that are absolutely no problem for us. We like doing this stuff. This is what we do. We got criminal defense lawyers at our firm who like to defend people in court. So why would we set the thing up so we don't have anything to do and sit around? Our team is excited. When somebody calls and says, hey, we got a great case, everybody's excited. They're arguing about who's going to get to go to court and fight this one. So we have a completely different attitude than these insurance-based companies that are looking for all these reasons to say, sorry, no coverage for you. We're like, hell yeah, bring it on. This is what we do.
Yeah, awesome. All right, they're telling me that's all the time we got. What a fun
Already?
live stream.
How
Yeah,
can it be?
That flew by, man.
Wow, so fun. I wish we could do one of these every day.
We'll
I
have
love
to do
them.
another one soon. I know that you're going to be out of state for a little while here working on some federal cases over in Hawaii, but
That's right.
I don't know, maybe we can do a Zoom one or something like that. We'll
I'm
have
up
to talk
for
to
it.
marketing. And we got to change that hold music, Mark. I can't tolerate the nasty comments again. They're right. That's
They are
that's
right.
the issue.
Yeah, we'll
That's
concede
all
when
right.
we're wrong. Right?
All right, guys. Thank you very much for tuning in today. This has been Attorney Andy Marcantel and Attorney Marc J. Victor. Don't forget to check out attorneysforfreedom.com to learn all about our law firm. Remember, if you don't like the law firm, don't sign up for Attorneys on Retainer. But if you like what we're about, if you go on there and you see the types of cases that we do, what we stand for, what our principles are, and that sounds good to you, then you should definitely visit attorneysonretainer.us and see what our program can do for you. Until next time, my friends, Attorney Andy Marcantel, Attorney Marc J. Victor, signing out.
Peace.